I call the member for Newtown.
Thank you, Mr Speaker. I rise on behalf of the Greens in this House and also as the New South Wales Greens portfolio holder on tenancy, rental and including strata. The reality is that more and more people are living in properties that are part of strata schemes, and as the Minister noted in his speech, there are approximately 75,000 strata title schemes registered in New South Wales, with over 100 additional schemes being registered every month. The vast majority, around 90% of those schemes, are residential. The number of people living in strata scheme properties is going to increase as our population increases and continues to grow. I would like to acknowledge the consultation that has occurred on these bills with key stakeholders and particularly note the submissions made by those to the draft bill released in July 2015 for consultation, including the Australian College of Community Association Lawyers, the City of Sydney, the Combined Pensioners and Superannuants Association, the Council of the Ageing New South Wales, Financial Rights Legal Centre, the Law Society of New South Wales, Legal Aid, the Owners Corporation Network, Shelter New South Wales and the Tenants Union of New South Wales. It is clear that there was a need to review existing strata laws and that the improvements to the Strata Scheme Management Bill are, on the whole, something that we will support. I wish to move a couple of amendments in relation to that, and I will foreshadow those now and come to it a little later. I'd also like to acknowledge that in relation to the review process that this Minister and previous Ministers have engaged in a wide-ranging consultation, and acknowledge my colleague, Greens colleague John Kay in the Upper House that used to have courage of the strata portfolio previously. But I would like to first address the serious concerns about the Strata Scheme Development Bill and say up front that the Greens do not support this part of the bill, and particularly we have concerns about Part 10 of the Strata Scheme Development Bill, which deals with the sale or redevelopment of a strata scheme. Our primary concern with this legislation is that the change to the requirement of owner approval needed to sell the scheme will reduce from 100% to 75%. On any measure, this is an exceptionally low standard or threshold for which owners of properties, people living in their homes, can be kicked out and required to be kicked out of their homes. And we've heard many in the government side, including, I believe, the Minister himself, referring to the fact that by 2040, half of Sydney's residents will be living in strata-titled residential properties. Under these changes, that means by 2040, half of the Greater Sydney region's residents will be living with uncertainty, will be living with insecurity. They will be unsure as to whether or not at any point their home will be able to be taken from them as a result of these new laws. We know that being able to live in a safe, secure, affordable home environment is one of the best indicators of well-being in our community. We know having a secure place to call home is one of the most important indicators of what is a healthy and stable society and community. And what we're saying is that by 2040, under this legislation, 50% of people living in the Greater Sydney region will be constantly living with the threat and insecurity around the fact that at any stage their home could be taken from them. We have been contacted by many members in the community who are extremely concerned by this proposal, and understandably they fear that their home, which is a unit in a strata scheme, can be forcibly taken away from them. Many of them are older residents who, after working for many years, have invested in a property that would provide them with security for later in life. In his second reading speech, the Minister claimed that this legislation would empower strata owners to make a collective decision about the most important issue that will confront all strata buildings at some point, but what to do with buildings as it ages. However, there is no requirement in this legislation for there to be an improvement as a result of this process. There is no requirement to address sustainability, housing affordability, or any of these other measures. So we have to ask, well, why is it that these residents, these people are being asked to give up their homes, forced to give up their homes as a result of this change? The absence of any requirement of positive outcomes demonstrates that this is not the intention of this bill. The intention of this bill is about people being able to make money out of the housing market. The intention of this bill is failing to recognise that actually properties that people own are not a way of making money. They are actually their homes. There are places where they live, where they have a connection with and a personal connection with. And surprisingly enough, I don't think when you ask any of the residents that are concerned about losing their homes whether or not they could value their personal attachment, I wouldn't say that the value of $26,710, which is the maximum compensation you get for a personal attachment to your property under this bill, would reflect in any way and shows perhaps the arbitrary nature of the attempt to compensate what is a very personal and very key factor in relation to people's connection with their homes. I want to refer specifically to one of the issues that were raised by one of the residents that contacted us. This person lives in Seaforth in New South Wales and had raised with us that they had bought their property feeling that it was in a situation, they took the time to handwrite a letter to us with their concerns, and they said that they had bought that property recognising that as a senior that would be their final home, their final place where they would be secure until the end of their life. This person is now living with the threat of this insecurity in what is a situation where they personally felt that they were taking control of their life, and now their home situation is under threat. What we see is that there is no requirements in this bill to improve the circumstances. If we were looking at a bill that sought to override some people because of the fact that we were seeing improvements to housing affordability, improvements to sustainability, then perhaps we could have a consideration of what that percentage threshold could be. But the reality is that we are seeing a threshold reduced from 100% to 75% simply on the basis of allowing people to raise money out of people that are actually wanting to consider a place to call home and have that security. In their submission to the draft bill, Shelter New South Wales observed that the forced displacement of strata title holders and residents into strained housing market, especially in Sydney, will have a significant negative social impact on those displaced. They have advocated for a model that involves independent review process for any dispute between minority and majority owners. A sale or redevelopment of strata scheme would be mediated, not forced. The Greens maintain that the residents should not be forced from their homes to make way for private development and profits of developers. Particularly, this is going to have a huge impact on older and vulnerable residents living in our city. The Minister has flagged a number of safeguards in relation to and support the protection of vulnerable owners through the strata renewal process, but I can say that those safeguards are not enough. Because what they do is they do not enable someone to have the security of a place to call home and to be able to determine whether or not they choose to get rid of their home or to move home. There is no safeguard that can be put in place that is strong enough to be able to protect someone from losing their home, and it is something that and there's the main reason why we strongly oppose this part of the bill. I'd like to foreshadow 3 amendments that we would like to make to the Strata Scheme Management Bill and say that while we welcome the changes to the approval mechanisms for cosmetic and minor renovations, and we recognise across the board the need for the Strata Schemes Management Bill and the improvements that it makes, that there are some changes that could be made to the way that tenants are involved and included within the decisions made by strata committees and involved in being able to raise concerns around the bylaws. I will foreshadow that they go in 3 areas. One is in relation to tenants being able to move a motion in relation to the strata committee. The other is enable a tenant's representative in any building or lot that is any building that is occupied by tenants. And the third is to enable tenants to be able to challenge bylaws within the tribunal. I would recognise, though, that on the whole, and I can talk to those amendments further later when we move to that stage, but I recognise on the whole that one of the concerns I'd wish to flag just at the end is the issue in relation to harsher penalties and infringements. And I would urge the Minister to respond to how we will ensure that tenants will not be unfairly targeted within the use of infringements in the bylaws. The other thing that I would note is that the Minister referred to the support that would be given to owners and tenants through the process, and I would really request that some sense of timeline or detail be provided on how that support will be offered to tenants and to owners that are dealing with the proposed development bill and the changes to the risks that they will have to the loss of their home. In short, I can say that the Greens are opposed to any bill that seeks to put profit before people's homes. To remove the security that people have, the right to live in safe and secure home environment is a fundamental thing that we should be doing to protect people's home environment, not to put developers first. And I hope that we can together actually put people and their homes first.